So I just would like to just say hello to everybody who is watching us now, and say that it's a seminar to discuss a draft of the Unidroit project on digital assets and private law. And me and Professor Juliana Kruger-Pella invited Mr. Hamza Hamid, who will tell who is the legal responsible of this project in Unidroit, and we'll make a short presentation, and we'll have some time to discuss the proposal thereafter. So thank you very much for being interested in this very crucial, important issue. And I think that the presentation of Hamza Hamid will be very welcome to shed some light in this complex question. Thank you, Hamza. Please take seat.
Excellent. Thank you very much, Professor, and thank you very much for your kind invitation to Unidroit and to me to come and talk to you all about the Unidroit project on digital assets and private law. Good morning, afternoon, evening to everyone that's here. As was said, my name is Hamza Hamid. I'm a legal consultant at the Unidroit Secretariat, and I'm in charge of facilitating Unidroit's project on digital assets and private law, which is what I'll be speaking to you about for the next 20 minutes or so, and then be very happy to have any questions come in online or on the live stream, however you'd like to do it. So as was indicated, Unidroit between 2015 and 2018 received a proposal, two proposals actually, one from the Czech Republic and one from Hungary, regarding some work related to digital technologies, distributed ledger technologies, including blockchain, as well as things such as digital properties. And then the idea was to look at these new emerging technologies with a private law perspective. As most of you will already know, Unidroit is the International Institute for the Unification of Private Law. And almost for the past 100 years, we've had a mandate to work towards looking at different issues, particularly commercial law issues and private law issues, and then examine how they're addressed in different jurisdictions, and then bring together the top legal thinkers in a particular area to put together an instrument that harmonizes and unifies a particular area of the law. So similarly, we were brought forward a proposal to consider work on digital assets. After doing some exploratory work between 2020 and 2021, the Unidroit Governing Council and Unidroit General Assembly ultimately decided that the best area for Unidroit to work on would be the issue of digital assets. And so we set up a working group which has now more than 80 participants, including members and observers from different parts of the world, including representatives from the industry, from different ministries, as well as private sector participants, to discuss several different issues relating to digital assets and private law, and put together a set of legislative principles that offer guidance on private law issues related to digital assets. The working group has met 7 times between 2020 and 2022, and the final meeting of the working group is expected to take place in the 2nd week of March. Alongside the working group, given the large amount of interest in this area, we also established a steering committee composed of Unidroit member states. So we had more than 25 member states in a steering committee who were given the opportunity to comment and provide feedback on the principles as they were being developed. So we've consulted the steering committee already twice, once in 2021 and once in 2022, and we've now opened up the principles again for a final consultation. The whole idea behind these principles was to put together a set of legislative ideals and principles that embody best practices and international standards when it comes to issues related to private law and digital assets. These issues include items arising out of the holding, transfer, and use of digital assets across a variety of commercial use cases. And then the principles would include a commentary on practical problems with regard to digital assets. Additionally, it would only focus on private law issues, and the instrument would take an iterative and functional and technologically neutral approach. So what does all of that mean in real terms, right? So to give you a short and quick example, on this slide, you see pictures of two digital creatures that belong to me. These are ERC20 tokens that sit on the Ethereum blockchain. And I bought them using Ether, which is the cryptocurrency that's used on the Ethereum network. Now, in 2019, a similar type of creature, not one of these two, sold on the Ethereum blockchain for more than $150,000. And a lot of these can have a significant amount of value. They are NFTs associated to a token that's on the blockchain. And so given that these things can have a lot of value, what happens if I decide to go to the bank and tell a bank that I want to borrow money and want to use one of these creatures or one of these tokens as collateral? Would the bank be able to take a right or interest, a proprietary right or interest in my asset in exchange for funding? What happens if I stop paying? Can the bank enforce its proprietary right in an NFT or in a digital asset of any kind to be able to take control of that asset and find its investment or recognize its investment? These were all questions that we set out to answer in this instrument. So over the years, we've worked on a lot of different issues, and the digital assets and private law principles presently have this structure that you can see on this slide. The instrument starts off with a detailed introduction outlining things such as the purpose of the principles, such as who they're addressed to. So for example, the primary audience is legislators and judges and governments that are looking to reform their domestic laws with regard to digital assets, and to put in private law principles that are established international best practices in order to facilitate the growth of their digital asset industries. The principles then go on to have a section on scope and definitions, give a lot of detail on private international law issues, so conflicts of law issues. Then they move on to the concept of control, which is quite important for the whole idea of having a proprietary right in a digital asset. They then detail issues related to custody, secure transactions, procedural law and enforcement, and finish with a section on insolvency. Now, I will go through some of these sections very quickly, but not all of them, because that would take a much longer presentation. But I do welcome questions on any parts of the principles, and do invite you all to go through them as you want to. So jumping in, and then before I start, it's important to note that the text that I will be reading out and then pointing to, it was the text of the principles in January 2023. The text has not yet been finalized. The idea is that the finalization of the work will take place in March, and then the instrument will be adopted and hopefully approved by the Unidroit Governing Council in May. So that's when the final text will be published, but this is what the principles look like right now. And we do anticipate this to be a very close to the finish line draft of the instrument. So the principles start off with a scope setting exercise. It's very clearly laid out that the principles deal with private law relating to digital assets. This ensures that no one confuses these principles as dealing with things such as public law issues, such as regulatory issues, or things that would fall into the public domain. It's more to do with contractual, with the relationships between parties of a private nature, rather than public law concerns that digital assets might create. Principle 2 then goes on to define what a digital asset is. It also defines an electronic record. This definition is consistent with the definition of an electronic record in the UNCITRAL model law on electronic transferable records. And then principle 2.2 defines a digital asset as an electronic record, which is capable of being subject to control. Now, this subject to control element is perhaps one of the most important and fundamental characteristics and aspects of the Unidroit principles on digital assets in private law, as this is what showcases or establishes the existence of a proprietary right within a digital asset for a particular person or party. A digital asset under the scope of our principles is only a digital asset if it can be controlled, and then control is later on defined in principle 6, and we'll dig into that later. Principle 2 also defines what is a transfer of a digital asset. So it describes a transfer of a digital asset as a change of a proprietary right in the digital asset from one person to another. And then it goes on to discuss some more details with regard to the grant of a security right and who a transferor and a transferee is in this context. Principle 3 of the principles talks about some general principles that are set out right at the beginning. The most important being principle 3.1, which clearly says that digital assets can be the subject of proprietary rights. This is a matter that's been highly debated across jurisdictions and in courts, and there's been a lot of lack of clarity with regard to the proprietary nature of digital assets. So the Unidroit principles on this matter very clearly start by indicating that digital assets can indeed be the subject of proprietary rights. Principle 3.2 then talks about principal laws taking precedent over other laws to the extent that they conflict. Principle 3 then goes on to put forward some exceptions and some things that the principles do not apply to, and things that are covered by other law. So examples of this would be whether or not a person has a proprietary right in a digital asset. This is to be determined by other law. What is a proprietary right generally, the rules for creating a security right, the rights between transferors and transferees, etc. The requirements and legal consequences of third-party effectiveness, for example. These are all matters that will be determined by other law and generally other private law related instruments within any jurisdiction. It's also important to point out at this stage that the principles do not apply to this idea of a linked asset. So very often you find that a digital asset might be linked to another asset that might be off-chain, or that might be an asset in the physical world. While the principles do apply to the digital asset aspect of this, what constitutes that link, the legal requirements for that link, and the effect of that link is for other law to govern. Principle 5 is one of the most important and highly debated and discussed parts of the Unidroit principles on digital assets and relates to conflicts of law. I would recommend you to go through this principle and examine it in detail, but it starts off, it uses this waterfall structure whereby it starts off by referencing the rules specified within the digital asset, should there be any, then the rules specified within the protocol or the network that the digital asset is on, and then goes on to provide for a system where the conflicts of law rules can be found in domestic law, or these principles themselves can be used in order to look at the conflicts of law issues with regard to digital asset. I would really recommend you to look at the principles for Principle 5, as a lot has changed in recent times. Next, we move on to the definition of control, which is, like I said, one of the most important aspects of the digital assets principles. This says that A person has control of a digital asset if this person has the exclusive ability to prevent others from obtaining substantially all the benefits from the digital asset, the ability to obtain substantially all the benefit from the digital asset, and the exclusive ability to transfer all of what was mentioned in part 1 and part 2, which essentially is the ability to enact a change of control. There is also a requirement that the person should be able to identify themselves as having all of the abilities mentioned in 6.1, but this is generally not for the person to prove, but for someone to disprove. The principle also talks about what it means to enact a change in control and recognizes the industry-specific things such as the destruction of a digital asset and the creation of a new one, as well as the process through which digital assets generally travel through any blockchain. Section 3 of the principles also has an innocent acquisition rule, as well as provisions relating to the rights of a transferee, which are useful to examine, but we won't have time to go into that right now. Principle 10 then looks at custody, which is very relevant in the context of a digital asset, as a lot of people use or transact with digital assets through the use of a custodian. A custodian is a person, as per the digital asset principle, who provides services to a client pursuant to a custody agreement. And then the principles go on to define what a custody agreement is, as well as what it means to be a client and what it means to be a sub-custodian. Principle 11 then describes a lot of the duties owed by a custodian to its clients. This describes duties that a custodian must owe to a client, as well as duties that a client may owe, a custodian may owe to its clients. These include things such as the custodian not being authorized to transfer the digital asset or use the digital asset for its own benefit, the custodian being obliged to comply with any instructions given to it by the client, as well as for the custodian to safeguard the digital asset on behalf of the client. The provisions in Principle 11.3 also talk about things such as there being an obligation to keep the assets of a client separate from those assets held by the custodian on behalf of other clients. So to not use, to use separated accounts rather than pooled accounts. The custody section also has rules relating to what is an innocent client, specifically the duties owed by a custodian, as we were talking about just now, as well as several other aspects of custodianship. Section 4 deals with secure transactions. This reiterates that digital assets can indeed be the subject of security rights, and that if a digital asset is linked to another asset, other law applies to determine the legal effect on that other asset of the creation of a security right in that digital asset. If a digital asset is linked to another asset, other law applies to determine the legal effect of that other asset and the mechanism through which that security right becomes effective against third parties. One of the important elements of the secure transactions law section of the principles is that it recognizes control as the method of achieving third-party effectiveness of a security right in a digital asset. And it also gives some guidance on the priority of security rights in digital assets, as well as mechanisms to enforce security rights in digital assets. And I'm short on time, so I'll quickly run through the next two slides. But Principle 18 talks about procedural law and recognizes that in terms of procedural matters, including enforcement, in terms of enforcement, procedural law generally applies to digital assets as well. This procedural law is other law and is not found within the digital assets principles. Finally, Principle 19 is a principle on the effect of insolvency on proprietary rights in digital assets. This principle talks about what happens when a party that holds digital assets becomes insolvent, and offers some guidance on this matter. This is obviously any situation which is not a custody type situation and a general situation. So it explains how insolvency would operate for a person or a party that holds digital assets. Now, importantly, all of these principles come with extensive commentary, which I would recommend you read in order to understand the guidance being given and who the guidance is for. As I noted right in the beginning, at the moment, the digital assets and private law principles are open for a public consultation, which is available until the 20th of February, 2023. We invite all interested stakeholders to participate in this public consultation, and all additional information can be found on the link that I've inserted into the slide. And I'm very happy to make the slide available after this whole presentation available after we've finished with our session. So thank you very much. I'll stop there, and I remain available for anyone who has any questions or comments, and would be happy to discuss. So thank you, and then the floor is back to you.
Thank you, Hamza. Thank you very much for the excellent and very lovely presentation. As a matter of fact, I didn't know in advance how detailed it would be, and it was quite interesting to see the presentation of the whole principles. At least it's black letters who are the first time to be read. I have prepared a short presentation. Let me try to share it. So, do you can see my presentation? Okay. I have prepared some aspects that are already presented by Hamza, so I will not say it again. And I especially will focus on the aspects of the precedence of principles law over other law, and also some international private law issues. Maybe I can bring a contribution in these aspects more than in others. I think that some states and many people think in terms of a red light that appears every time we talk about digital assets. That's the risk to bypass state taxes and state regulation, especially state regulation. And one thing that was very clear in the principles is that there was a concern and a very careful dealing with this issue, and it was done as setting the scope in private law, and private law as proprietary rights in digital assets. That means it's a relatively narrow scope to the principles. It's not a broad scope. It does not go to public issues. It's particularly interesting to stress that the wording such as public law or administrative law or expressions alike, this does not appear in the principles. It is obviously intentional. As I was discussing with Juliana previously to the presentation, there is no word in this draft that is accidental. It's obviously intended to, and it's interesting because both the idea of other law and the idea of non-private law are important to understand the scope, the material and legal scope of the principles. It's important because the meaning of principles law is very, very specific. I mean that at least a Brazilian lawyer who reads principles law would not reach the understanding that was set in the principle 3.2, especially that principles law is the part of state's law which falls within the scope of these principles. It's important because principles law takes precedent over other law, including state's law, which falls within the scope of the principles. And the scope is the scope as it's set in the article, in the principle 1. That means private law related to assets, but to linked assets. The digital part of the linked assets is regulated by the principles, but the non-digital assets are not object to the principles. It's important to does not allow the use of the principles to bypass state law in regulatory issues. The idea of other law is a supplementary and residual idea. That means anything that is outside the principles are other law. Other law is state law, but not only the state of the forum law, but any other law, international law, domestic law, lex fori, lex causi, everything is other law as far as they are not principles law. That means it falls outside the scope of the principles. This delimitation is very important to secure the states against the use of the principles as a way to bypass national regulation. Going to the issue of the conflict of laws, it's very interesting to stress that proprietary rights is usually under the lex re site principle in international private law. The traditional rule of lex re site is not used in the principles, but it's substituted to the law specified in the asset or in the system or in the platform that's related to the digital asset. It's closer to the idea of lex voluntatis, the voluntary law, the law chosen by the parties in a contract, or the law that parties can choose in the resolution of an obligation. But it's not very usual to rights related to land or to other rights in immovable goods and goods in general. That's interesting because it's used a criterion that's closer to obligations or contract law than to law of proprietary rights or property or ownership or tenure law that usually are closer to the territorial law. Probably the idea behind this is that in relating to digital assets, sometimes it's difficult to make clear in which territory they are. And the idea is to establish that nor a territorial criterion nor a personal criterion are relevant, but the expressly set criterion by the parties. If in the asset itself or in the system or platform itself, the rights are have a domestic law linked to, that law is the law that will govern all these aspects. A moment, please. Love you too. I'm sorry. It's also important to understand that the territorial state of the asset is not very important to the principles, but the main idea is the forum state. That means the main link to a state recognized clearly in the principles is the link by the procedural jurisdiction of the state to decide in a cause related to digital assets, probably also a question related to insolvency, but there are some alternatives, and at least the default, the residual rule is the criteria of the Lex 40. That means if everything else fails, the Lex 40 is the rule that will be applied to the digital asset. So I already said that they don't use the Lex Recite, and there are some reasons therefore. And it also goes beyond the traditional criteria for invisible and intangible assets, especially intellectual property assets that are established and regulated by the territorial law of the enforcement state. And it's what is retrievable to uniform law and international laws such as Paris Convention, Berne Convention, other OMPI treaties, TRIPS, regional trade agreements, international investment agreements, and so they usually constitute the invisible and tangible assets accordingly to the territory where these assets are to be used or imposed against third parties. And this is not a criterion used by the principles, and it's interesting because they propose that the principles is the main rule to private aspects of digital assets, and the remaining state law is used as a residual law. And well, it's interesting related to international private law issues. There is nothing said about public order, mandatory rules, immediate applicable norms. That means the biological relations between principles law and the other law is in the principles system enough to establish which is the applicable law and in which proportion the applicable law is to be taken into account, without any resort to concepts of the exceptions of application of a foreign law or international law based on public order, mandatory rules, or other kinds of rules. Obviously, there is a general exception to the non-private law issues, but it's important to understand that the principles adopt a logic that is not does not depend on the public order theory in international private law, and it's also a very interesting issue. If I could make any so to say contribution to the principles that to my knowledge are very well drafted and makes much sense for me in many aspects, and is a very, very important instrument to be studied and understood also when the states are to set their own rules on digital assets. I would try to make clearer the relationship between principal law and applicable law. From my understanding, the first law to be applicable are the principles law. The material aspects of the principles law are the predominant law. Thereafter, we go to the law determined by the parties in the title itself, or by the state, the foreign state, or so on. But the main law is the principles law. And some wording in the Article 5, in the Principle 5, relating to the use of domestic law, sometimes is misleading in this sense. Sometimes it appears that the state law, the domestic law, goes beyond the reach of the principles. But the principles are supposed to be the law that has precedence over all other issues. It should be put also in the international law article in some way, maybe a disclaimer or something in this sense. On the other hand, I think that some people who is used to this discussion in international private law would see if not a red light, at least a yellow, orange light on the issue that there is no provision about public order. And I think that a disclaimer, maybe in the comments, maybe in the introduction, would be useful to alert people that, okay, everybody knows that this issue and this question exists in international private law, but it's a technical, well-guided option of the principles not to use this kind of exception, because the logic is distinct. We use the principles, then the state law, and thereafter other law that's not the state law related to the principles. That would be my ideas about how to contribute in some fashion to such a good project. And I thank to the public and also to Hamza and Juliana for the patience in hearing me to talk about these issues. And I would like also to ask Juliana to take the stand and talk to us about her possible remarks. Thank you. Thank you, Juliana. Please take stand.
Thank you, José Augusto. Thank you, Hamza. I would ask Hamza if he wants to make some comments on what you have just said, and then, because I will change subject, Hamza. I am a professor of private law, commercial law, so I'll change subject a little bit. If you want to make comments on José Augusto issues on international law, I think it would be better. Thank you.
Absolutely. No, thank you very much, Professor Jose and Professor Juliana. Just to start off by saying that I'd like to clarify that the slide that I had on the conflicts of law principle was the older version. I realized when the slide was on the screen. I have updated it now, and I will send it to all of you afterwards. And the conflicts of law principle you showcased with option A and option B is the latest draft, and that's what we're working on. And I would really, encourage you and request you to please, submit the comments that you just made through the online form we have, because this is exactly the type of feedback that we are looking for and we have received already from several stakeholders. The Principle 5 is by far the most commented principle, and we're not surprised. I think a lot of the rationale behind Principle 5 comes from two ideas. The first one being this entire industry, which operates on the idea that no law applies to what they do, which is not true, which can never be true. And then to sort of rein them in and encourage them to apply best practices and standards. So the top of the waterfall that you see, which relates to the choice of law being found in the digital asset or being found on the platform, we recognize already that a majority of digital assets do not do this. So if you pick up the Ethereum blockchain or the Bitcoin blockchain or the hundreds of dApps and DAOs that are built on these platforms, maybe one or two has a choice of law in it. A majority will not. And so we will come down to the bottom of the waterfall and try to find the solution in those provisions. But the hope is that through this international best practices document, the industry will be encouraged to include a choice of law provision in their products and in their digital assets that they develop in the future. And we've already seen a trend towards this, but we hope it grows more and more. And then the second element is the fact that these assets don't have a location. It's very hard to find a party or a person or a location for the asset because they exist primarily entirely in cyberspace. We drew analogies to intellectual property. We drew analogies to other areas of law where we had these assets that had no physical presence. And that was some of the guiding thoughts behind the way that the waterfall was structured in the end. But we of course expect completely for states to adopt it based on their domestic law structures, and we would very much welcome feedback to fix it or to improve it, I would say. So please do submit that. And I think on the public order issues, I'm a little less sure about the position of the working group on this, but I know we've talked about it, and we chose to stay away from it because that's where you sort of move towards the regulatory side of things rather than the private law side of things. And we do try to talk about this in the introduction, but if you do, submit that, then maybe we can expand upon it in the introduction. So I think all of those are good comments to collect, and then we would be, happy to hear more. Thank you. I'll stop there.
Thank you, Hamza. I have just a thank you very much for your comments. I will, of course, present written comments in the site. Don't worry about that. But I would like just to say a thing. If you go to the literature on contract law of the 1950s, 1940s, it's not rare to find people who says, oh, a clause of applicable law in international contracts is not very usual. Nowadays, it's impossible to think about an international contract that has no clause of arbitration and applicable law. And of course, if an international contract today has no applicable law clause, it's because the parties don't want to put such a clause. It's not something that was just forgotten. And I think that the same thing can happen with the digital assets, and it's very important to be so. On the other hand, I think that it's a very good caution to have a provision that says that the party, when the party buys or takes a digital asset, they agree with the applicable law. It's a very good presumption, and the URI presumption, it does not admit proving contrary, I think. Maybe this aspect could be a little clearer, but it's a very good idea to have such a definition. Although I think that the simple expression of the applicable law should be sufficient to set this law, not depending on the voluntary adhesion of the other party, because it also affects third parties, and third parties have no consent to it. So it would be useful too. Thank you, Hamza. Thank you, Juliana, for letting us discuss this a little longer, and please take time.
No, please, very interesting for me, this discussion. I would first say, Hamza, that's very interesting what you said, that you, the group, thought about using the IP assets as a model or something similar to digital assets. But in fact, it's very difficult, because IP assets are registered before a national authority. So it's very difficult, as you said. Digital assets are not localized. You cannot localize, and IP assets can be, because of the register before this national authority. So I see the difficulty, but it's very interesting, the parallel. But I would like to take this opportunity to ask some questions to you, because I was wondering why the draft uses some terms, some expressions that mean something very precise in national laws, and why did you choose these words, these expressions? For example, the draft uses the term control, and it's defined in Principle 6, very, very well defined. But also the draft mentions proprietary rights. And for me, it was a little bit confusing, because it's not property, it's control, but the draft means proprietary rights and does not define proprietary rights. So I really want to hear more about this, if you could clarify and explain, because as José Augusto said, we know that nothing here is doesn't have an explanation and a justification. It's very well fundamental. So I want you to explain to us why this choice, control, on the other hand, proprietary rights.
Thank you very much. I must start by caveating that I am not a private law expert. I facilitate the working group, and for the entire time the project was being run, I was the technical lead, and then now I lead the whole thing. But I can definitely speak more about the use of the word control, which, as you said, in Principle 6, you'll find in the commentary that it's very clearly set out that the word control is not being used in a legal sense. It is intended to be the functional equivalent of possession of movables, rather than the way control appears in certain jurisdictions in a legal sense. So it's factual control rather than legal control. And this was a choice made after a lot of careful consideration of the different words that we could use. We examined in words including power, ability, and possession, but ultimately this is the model that's been adopted in different parts of the world already. So you will find that this is also in line with the recent reform of the Uniform Commercial Code in the United States, as well as in line with the proposal of the Law Commission of England and Wales in the UK, all of which describe the act of holding a digital asset as control over a digital asset. So it's factual control, not and functional equivalent to possession rather than legal control. With regard to the use of the word proprietary rights rather than property rights, this was again discussed at length, particularly by several of our colleagues that come from civil law jurisdictions. Ultimately, it was found that proprietary rights had more of a broader sort of application than property rights. But for that particular question, I would definitely point you to some of our experts in this area, including Professor Louise Gullifer and Professor Philip Pike, who led the work in this area and are much better experts than I am.
Thank you.
Thank you.
Fontoura, do you want to?
Oh, no, I think that your questions are very interesting. As a matter of fact, the control is one of the main aspects of the principles, as far as I can see. It's what defines an asset is the control over the asset, and the control has a relation to the traditional aspects of property in Roman German systems. I mean, property is something that can be used, property is something that can be transferred, and property is something that can be opposed to third parties. So it makes a lot of sense to me. Although it's not completely clear, but I think that's good that it's so. That it's related also to a technical and effective technical possibility to exclude other people and use exclusively the benefits, not as a result of the legal regime of digital assets, but by the technical means used to create this exclusive use and possibility of transmission of this asset. Juliana, please.
No, I would say I agree with you, and I would say what's interesting here is that for us, control or property is a legal term, as Hamza said, and here the draft has made an effort to say here control is a is a factual term, it's a factual expression. But when it defines control, it's the exclusivity ability of something. And for us, the law is the one, the thing that gives to someone the exclusivity power to transfer or to use an asset. And here it's very interesting because in a digital asset, you have to recognize that the technology or the way this digital assets is used gives to the holder, to the one who controls, this ability, this exclusivity ability. And that's what's recognized by the expression and the concept control. So I think it's a little bit different the way we think on legal terms on property, because we think of property as a legal term. So the law will give to someone the power to have the exclusivity. Here, you see the exclusivity and then you recognize control. So it's the other way around. That's what I understood, Hamza. I don't think if it's, I'm not so sure. So if I didn't understand correctly, please say me.
Oh, yes, I have some doubts when I was reading the document also in this regard. But I was convinced that it's a factual thing, that the control is a factual control. And also in the same line that Juliana presented, I would stress that intellectual property has these characteristics that were explained by Juliana. That means, I don't know, a patent or a trademark or even a copyright is set by law. It's not a natural thing of this right. The right is created by law. But in the case of digital assets, the technology allows the asset to be exclusive and exclusively allowing these abilities to the holder or the people who to who these assets belongs to. We are correct, Hamza? Is this sense?
I think there is a lot of alignment, particularly what you said, you know, in the middle about control being purely a factual exercise. I think the abilities talked about in the definition of control add to the factual nature of control rather than taking away from it. The abilities relate mostly to having the capacity to exclusively use the asset and derive benefits from it, and then recognize the technological caveats that you might be sharing your control with other parties if that is using things such as a multi-signature wallet, etc., which further go on to, you know, describe the factual nature of control rather than the legal nature of control, and more reflect what in most civil law countries is possession rather than control. So that we're all on the same page. There might be, you know, differences in the application of the term, and this is something we do welcome feedback on for sure. Yeah.
Yes, sure. The possession concept is the concept that is closely related to this factual control over the movable thing. I mean, I have the possession on this cup, and it's okay. It's clear too. I think it's clear. So
I would only comment, Fontoura, that
yes,
but when we read in the same document proprietary rights and control as a factual, as similar to possession, for us, the civil law countries, we became a little bit, it's a little bit confusing because proprietary rights is not defined here. Maybe it would be good, be worthwhile to define proprietary rights here. I don't know, but because I read in the item commentary 2 of principle 6, it's written that it's similar to possession, and that brings us in civil law country to a regulation, a regime of possession that's very specific and contrary to proprietary rights in a broader sense. I don't know, that's my first impression, Hamza. It's a contribution from a civil law country perspective.
We certainly welcome that. I mean, please do reach out through the feedback form if you think that would be useful. Including a definition of what a proprietary right is has been discussed repeatedly for the past 3 or 4 sessions. It's also very hard to define what a proprietary right is because different jurisdictions do it differently. And so we didn't want to ring fence that. There is a paragraph, particularly in the introduction. If you look at paragraph 14, then right at the beginning on page 5, on page 5, paragraph 14 clarifies that, you know, the proprietary aspects, what proprietary aspects are, and why proprietary rights is used instead of property rights. But again, these are things we'd be very happy to hear more feedback on.
Oh, yes.
Perfect.
Please, Juliana.
No, perfect. On the other hand, it's also written that the subject of digital rights to security rights is an aspect of proprietary rights. So we know that security rights are part of it, but not the total of it. So that's why I was thinking about having a more complete definition in the draft. But sorry, Fontoura.
No, the thing is, it's very complicated to do the wording of these things, especially between the both Western legal traditions, the common law and civil law. There are a deep divide and terminological divide that is very complicated. And maybe proprietary rights is a good word exactly because it not belongs both to civil or to common law usual lawyers wording. I mean, it's not ownership, it's not property, it's something different from it. I would just remember a definition very common in law and economics literature that says that property is the legal attribute of something that can be used with no need for further contract or transaction. I mean, I have property when I can make use of something without any consideration about other parties and so on. But I just remember it because I like this kind of literature, but it's obviously complicated to define it, especially when we have lots of jurists trying to make their ideas to be the dominant ones. So I would like to know. Yes, please.
I would just add that it's an entitlement, as you said about the law and economics literature. I remember Calabresi, and he says it's an entitlement, one of the entitlements that are possible in private relations. So control here is an entitlement in a sense. So it's interesting to see how the concept doesn't fit very well to digital assets, and you have to create some different expressions.
So before getting this short seminar session to an end, I would like to ask if Juliana or have some final remarks to make. Do you?
No, I would like to thank you and to thank Hamza. It was very interesting to read the document and to think about it. I am sure we are going to discuss this document a lot of times. So thank you, Hamza. Very congratulations for your work. And thank you, Fontoura, for the invitation. Without your invitation, I wouldn't be aware of the document with this discussion. It was very interesting. Thank you.
Yes, sure, Juliana. Thank you very much. I think that one of part of our jobs as international lawyers to make international law and uniform law known for the other fields and other professionals of law. And I would like to finally to give back this time to Hamza and ask you to close our session. Please feel free.
No, thank you very much for your kind invitation again. And this is exactly what we want. We want to hear from jurists and legislators and stakeholders from around the world and receive feedback on this instrument that we've developed over the past 3 years or so in order to improve the instrument and then encourage its adoption once it's finalized. We've in fact been very privileged and lucky to have a lot of input from Brazil on this instrument. In fact, as part of the steering committee, I think both the Brazilian Central Bank as well as another agency contributed comments to the principles, which were all considered. So we really do welcome a lot of this feedback and then hope to continue to engage you and implement a lot of the feedback that we receive so that we can adopt an instrument that is then applied and useful in growing and promoting the digital economy in all parts of the world. So thank you very much for your invitation. And if there's anything else that I can do, I'd be very happy to help. And I'll definitely email both of you my slides immediately afterwards. Thank you.
Thank you. Goodbye. Hope we keep in touch.
Thanks. Thanks, everyone. Bye.
Bye-bye.
Bye.